Hello, everybody. Good afternoon. My name is Cassie Pajarillo Braganza, and together with the Cine and the Cine Booted the Cine Law Office, we wanted to welcome everybody who's joining us today's webinar. And today's Doing Digital Business. We are going to be talking about doing e-businesses, electronic contracts, documents, and signatures. So as the new normal sets in, it has become essential to conduct businesses electronically. To celebrate the 20th year of the E-commerce Act, which recognized the validity of conducting business online, we will discuss electronic contracts, specifically the legal recognition of electronic documents and electric signature. Although we are going to be learning more on terms of how it's being executed, we are also going to be talking about how is it proven in court through the rules of electronic evidence. So again, today's agenda, we are going to learn the basics of E-commerce Act and the basics of the rules of electronic evidence. Our speaker for today is none other than attorney JJ Dicini. After graduating Dean's Medals from the UP College of Law, so let me just introduce him as well, placing him seventh in the bar examination. JJ has been continuously practicing law in 1994. In 2004, he obtained a degree in Masters of Law from Harvard Law School. And in 2000, and also he is the first lawyer. I'm so sorry about that. He is also the first lawyer member of Philippine Internet Commerce Society and was actively involved in the lobbying efforts for the passage in the E-Commerce Act. He drafted the implementing rules and regulations under the supervision of Control and Interagency Task Force Committee, co-chaired by the Department of Trade and Industry, the Department of Budget and Management of the Bangko Sentral ng Pilipinas in 2000, and a year later, he co-drafted the rules of the electronic evidence as part of the Supreme Court's e-commerce subcommittee. Attorney JJ is a frequent speaker in legal forums such as this and a news and current affairs programs on television where he discusses issues involving e-commerce, cybercrime, data privacy, and intellectual property, among others. He is also the professor of UP College of Law, where he teaches the law of cyberspace, advanced issues in intellectual property, builds notes, credit transaction, torts and damages, and negotiation and mediation. He's also the professor of Philippine Judicial Academy. I know these are a handful, but it is very important that you do know about Attorney JJ. Okay, so the floor is now open. If you have any questions, please type it down below into the Q&A section, or just feel free to comment it, and we are going to monitor each of your comments through the forum comment box. Okay, so we'll call on Attorney JJ, who is now going to discuss about today's webinar. Hi, Attorney JJ.
Hi, good morning, Cassie. Am I coming in clear?
Yes, yes.
All right, let me see. I'm share my screen here. Hold on. Sorry, good morning, good afternoon to everyone. Thank you for joining our webinar today. And so we will be discussing doing business electronically, which has become sort of a priority issue for a lot of businesses right now. Electronic contracts and electronic documents and electronic signatures. So coincidentally, this is in celebration of the 20th year of the E-commerce Act, which provides the legal basis for much of what we will discuss today. Okay, so what will we discuss today? So first, we will discuss the E-commerce Act and the legal recognition under the E-commerce Act of electronic documents and electronic signatures, as well as some points about electronic contracts and how to enter into valid electronic contracts. And then we will also discuss electronic evidence basics, because the rules on electronic evidence were enacted by the Supreme Court, promulgated by the Supreme Court the year after in 2001. And actually, we are very fortunate in that the firm was involved in the drafting of the implementing rules and regulations of the E-commerce Act, as well as co-drafted or participated in the drafting of the rules on electronic evidence 20 years ago in 2000 and 2001 respectively. So we'll just jump right in. No? So the first topic, of course, is the e-commerce app. And of course, the objective of the e-commerce app is to provide a firm legal basis for electronic commerce. So back in pre-e-commerce act, the big question was, if I enter into a contract using email, would that be enforceable? Would the law recognize it as valid, or will I have problems? Can I have it introduced into evidence? Can a court enforce it? And the bottom line is that around all of these issues, there's always that concern. But actually, the law already validated all of these things. But there's nothing like an express provision in law that says it is electronic, it is recognized, these types of contracts in electronic form are recognized, and the courts will enforce them. And that was what happened with the E-commerce Act. Now, the E-commerce Act was supposed to apply not only to actually originally, as you take from the title, it's only supposed to cover electronic commerce. And indeed, our e-commerce act is based on the UNCITRAL model law on electronic commerce, which was only supposed to cover business transactions or commercial transactions. However, in the Philippines, it has been expanded to cover also non-commercial transactions, and even things like family law and even wills. So you can have a will done electronically. Of course, it's tricky, especially in a notarial will, because we have no provisions now validating electronic notarization. Uh, Also, 20 years ago, the government or the e-commerce act provided for e-government, and in fact required all government agencies within, I believe, 3 years from the passage of the law to allow filing of electronic documents as part of required the filing of electronic documents as far as they are transacting with citizens. And also, one of the most significant provisions of that law was the enactment or criminalization of hacking or cracking. This is way back in 2000. And in fact, at the time that the e-commerce act penalized hacking or cracking, the Philippines had the most effective or the most modern, one of the most modern laws on cybercrime, because one of the things that we penalized under the e-commerce act was the act of interfering with the operation of a computer system, and that covered distributed denial of service attacks. And at the time that the law was enacted in 2000, I think the Philippines was only one of maybe 2 or 3 countries in the world that punished this as a crime. Okay, so just some basic principles that underlie the e-commerce act. First is the functional equivalence principle. In other words, the idea here is that anything in electronic form that performs the same function as a document or a signature will be considered that equivalent in the real world. So, for example, a signature, the purpose of the signature is to identify the person, and it's adopted by the person in order to indicate that person's consent, right, or authentication of a document. And therefore, anything in electronic form that performs that function, that identifies the person, that the person can adopt, and indicate his consent to a document, will be considered as an electronic signature, and therefore functionally equivalent as a handwritten signature. The second principle under the e-commerce act is technology neutrality, or in other words, the law is supposed to be technology neutral. In other words, it should not favor one particular type of technology. Okay, and therefore it should admit all types of electronic documents that satisfy functional equivalence as equivalent of a written document, and in much the same way accept any kind of electronic signature as a valid electronic signature. That at least is the principle. Of course, the implementation is different, as you will discover later. The third is media neutrality. In other words, since what is protected is information, then so long as that information transfers from one media to another, from a scanned document to an SMS, from an SMS to a fax, from a fax to an email, all of those are now considered part of the e-commerce act and covered by the statute. And lastly, of course, is the principle of non-discrimination. And in non-discrimination, the law is not supposed to discriminate between paper documents and electronic documents, between wet signatures and valid electronic signatures as recognized under the law. Okay, so what is the purpose of the E-commerce Act? The way that it operates is that there is legal recognition of electronic documents, electronic signatures, and of course, electronic contracts. So let's start with electronic documents. So in the E-commerce Act, an electronic document is defined as referring to the information that is generated, sent, received, or stored by electronic, optical, or similar means. So now you see that it's a very, very broad definition of what is considered an electronic document. What's interesting is that there is a Supreme Court decision where the Supreme Court, the Philippine Supreme Court said, and looking back at the Senate proceedings for the E-commerce Act, where the court said in that case that faxes are not considered electronic documents. Okay, this is because during an interpellation of Senator Magsaysay by Senator Miriam Defensor Santiago, she procured from him, right? She was asking her series of questions. Of course, she's a lawyer, and she must have intimidated Mr. Senator Magsaysay, who is not a lawyer, and asked a lot of questions. And at the end of the discussion, the sponsor of the bill, Senator Magsaysay, relented and said that faxes are not part of electronic documents, or the definition of electronic documents. And on that basis, the Supreme Court held that faxes are not intended to be part of electronic documents. However, I think the problem with that decision is that the language of the statute is very clear, that so long as the information is generated, sent, or stored by electronic means, in other words, if it is merely sent by electronic means, then it is considered an electronic document. And therefore, there's reason to believe that the Supreme Court did not follow, or I think should have followed, the express language of the statute. Also, I think the other thing to consider was that the language that of the statute, or the basis of Senator Miriam Defensor Santiago's questioning or interpellation of Senator Magsaysay, was that she was reading off the Canadian law, or counterpart of the Electronic Commerce Act. And in the Canadian law, faxes are excluded. So therefore, it was as if they were talking in that exchange with the Supreme Court references. They were talking apples and oranges. They were not talking about the same thing. I think if Senator Santiago wanted to have a discussion with Senator Magsaysay about this issue, she should have stuck to the definition in the UNCITRAL model law. Okay, so how does the E-Commerce Act recognize electronic documents? And it does so, as we've quoted here, in the negative. And it says that information, so remember, the electronic document is the information itself. It's not the electronic file. It's the information contained in the electronic file. Okay? And so the information, this information or electronic document, shall not be denied legal validity solely on the ground that it is in the form of a data message or an electronic document. So that is a recognition that it is supposed to be treated at the same way as electronic, as written documents. And really, that is the meaning of legal recognition. Legal recognition means that electronic documents, when something is in an electronic document and it satisfies the E-Commerce Act in terms of integrity and reliability, then it is equivalent to a writing. In other words, anywhere in the law that requires that something be in writing, it may now be in an electronic document. Okay? And these are examples, right, under the law where certain documents must be in writing, such as documents falling under the statute of frauds. Negotiable instruments, for example, need to be in writing and also signed. And of course, marriage settlements. So these are examples. An electronic document now can satisfy these requirements in order, right? In other words, if there is a verbal agreement and it is not yet performed under the statute of frauds, if that agreement can be documented by SMS messages, by emails, then it would be considered in writing. You will satisfy the statute of frauds, and therefore the contract will no longer be deficient. In the case of electronic signatures, what's interesting is that there is a disconnect between what the law defined as an electronic signature and what it finally recognized. So the definition, as you will see here, is very, very expansive. And in fact, the definition satisfies the functional equivalence principle, in the sense that any mark, right, any mark representing the identity of a person and attached or logically associated with an electronic document, uh, if it is adopted by the person, right, and with the intention of authenticating or approving a document, then that electronic mark or distinctive mark is considered uh, an electronic signature, and therefore satisfies the definition of an electronic signature. Now, question, is that electronic signature? Are all types of electronic signatures that fall under this definition, are they legally recognized? And sadly, the answer to that question is no. That in fact, the E-commerce Act only validates a small subset of electronic signatures, and that is governed by this provision. This is Section 8 of the E-commerce Act, and I've quoted here in full because it is, in fact, a very complicated statute, right? So it refers, all of these things have to be present, right? Before the signature, the electronic signature, is considered legally recognized. And what do I mean by legally recognized? It means that it is the equivalent, that electronic signature is equivalent to a wet signature or a handwritten signature, such that the document to which that electronic signature relates or is associated to is considered signed under Philippine law. So if something needs to be signed under Philippine law for it to have some significant legal effect, then that document must satisfy these requirements of Section 8. Now, a good example, for example, is a negotiable promissory note. So negotiable instruments law requires that negotiable instruments must be in writing and signed by the maker or drawer. If there's anybody out there who's a student of mine in negotiable instruments, which I've been teaching for about 20 years, you will know this provision well because I ask you to memorize it. Okay, so what is an electronic signature? What are the requirements in order for that electronic signature to be equivalent to a handwritten signature? So let's go to the first one. It says it is a method, right, unalterable by the parties, which is, and a method is used to identify the signer and to indicate that signer's access to the document. Second, the method is reliable and appropriate for the purpose for which the electronic document was for which it was generated. Okay, it is necessary for the parties sought to be bound to have executed or provided the signature. And finally, the other party is authorized or enabled to verify the signature. Now, this is a lot. And back in 2000, when we were analyzing this, about the only thing that we could see that satisfied all of these requirements is a digital signature within the context of what's known as a public key infrastructure. So that's a mouthful, and we will unpack that next week when we talk about electronic signatures. Okay, so questions, right? First, what about scanned signatures, or what I call digitized signatures? In other words, you have your signature, you scan it with the scanner, you store it in your in Microsoft Word, or maybe you store it as a JPEG, and when you're going to sign a document, you cut and you paste it on the document. Is that a valid electronic signature? So first, is it an electronic signature? Under the definition of the law, yes, it will satisfy an electronic signature, but is it a legally recognized signature? Sadly, no. Why? Because the requisites of Section 8, as I mentioned before, I'll bring that up again, they don't satisfy these requirements. In fact, there's a way, and I use this all the time, where you can scan your signature on Apple Preview, and even have it on your phone. And when somebody sends you a PDF, you can sign that document, right, using the functionality there. And it's an image of your signature, and you can even have a color to it. So you can use blue, you can use red, and then you can sign that document. So the document would not be considered signed, but that would be an electronic signature. Okay, so those kinds of documents, when you just slap on an image of your signature on an electronic document, it is not considered as an equivalent of a signed document under the law. Now, of course, there are other technologies out there. DocuSign is one of them. Adobe Signatures and Tiwala. Tiwala is a locally developed electronic signature system, and we actually hope to invite a representative to talk about Tiwala next week. And in those cases, I will reserve any comment right now. Tune in next week to find out. And finally, of course, as I mentioned, digital signatures under PKI would be considered valid in the Philippines. And there's some interesting thing going on right now. The Department of ICT is setting up, has set up actually a digital signature system, which it has offered to the government. And the big question now is, would those signatures be considered equivalent to handwritten signatures under Philippine law? We will discuss that next week as well. Okay, now, what about unilaterally signed documents? This is quite interesting because if you go back to the definition, if you look at the last requirement, I don't know if you see my mouse, the last requirement, which is the other party is authorized and enabled to verify the signature. So what this implies, right, what the law implies is that there are two parties to the signature, the signer and the other party. So the question now is, what about a unilateral document like a certificate or maybe an affidavit? In other words, there are no two parties. It's not a contract. It's merely an authentication of a document by the signer. Would that be covered by Section 8? And my view is yes, it would be covered. And that the other party, right, referred to in Section 8, would be not a counterparty as in a contract, but any party who is interested in verifying or authenticating that document would be considered that other party. In other words, any party who's interested in the truth of an affidavit will be authorized and enabled to verify the signature. Okay. And then finally, of course, and this is a big issue right now for lawyers, what about notarized documents? Are notarized documents covered by the E-Commerce Act? Sadly, no. But there is authority on the part of the law given to the Supreme Court to enact rules on electronic notarization. And in fact, Chief Justice Peralta recently constituted a committee to propose rules on electronic notarization. And this is a major issue because a lot of documents are required to be in public form. And of course, the reason why notarization is popular or almost always required by your lawyer is because there are evidentiary advantages of presenting a notarized document. A notarized document under our rules on evidence is a public document, and we don't need, as lawyers, to authenticate it anymore. All we have to do is prove the existence of the notarization, and immediately the document is admissible in evidence. And that's the reason why your lawyers require your documents to be notarized. Now, this now is a list of documents under the law which must be signed in order to have some validity. In other words, for example, a holographic will must be in writing and signed. Right? So the question now, what kind of signature? That signature has to satisfy Section 8. And if it doesn't satisfy Section 8, then you cannot have a holographic will. You cannot have these other things that are required in the statute. So one of the questions I think, or one of the concerns when it comes to electronic signatures is that, well, if there is limited recognition, is that bad from the standpoint of electronic signatures, or does that mean that we cannot enter into electronic contracts? Well, the good news is that the number of documents required to be signed under Philippine law is actually quite small, right? And therefore, in other words, contracts that have to be signed in order to be valid, there are only few contracts that fall under that category. And therefore, if you don't fall under that category, it doesn't matter whether that document is signed or not signed, right? Because it will still be valid under Philippine law. And we will discuss that a bit later about what the elements are of electronic contracts are legally recognized, which brings us there here now to this part on electronic contracts. And therefore, how did the E-Commerce Act recognize the validity of electronic contracts? Essentially, what it says is that so long as the offer and acceptance, right, and these are what is known as the external elements, right, the external manifestations of a contract. So long as the offer and acceptance and other elements required by law are embodied in an electronic data message, right, then they may be used to prove the existence of an electronic contract. Now, this is consistent with Philippine law, because Philippine contract law says Philippine contract law follows what's known as the spiritual system. In other words, contracts are valid in any form that permitted. So a verbal contract, an oral contract, for example, is considered valid under Philippine law. And therefore, you don't need a writing to do that, okay, or written document to do that. Now, so question, for example, what if you send an email? Let's say I send you an email or an SMS, and I say, if you want, you can buy my car, and I'll mention my car with the plate number, and I'll say, I'll sell it to you for 300,000 pesos. And you send an SMS back or an email back saying, okay, I accept. Now, that's the offer. My first email is the offer. The SMS message or the email message back is the acceptance. And both documents now, both electronic documents now, are proof and can be used as the basis to prove the existence of a contract. Okay, so that is one way in which you can enter into valid contracts by direct message, chat. In fact, there is a case in the U.S. very interesting where the that it was a chat, right? And on that chat, they amended a contract, which resulted in a ceiling of $5,000, resulted in a liability of about $1.5 million, about 1.5 million US dollars, all on the basis of two words in a private message, basically said no limit on the amount that they would book. Okay, so there's another type of contract which is very popular back in 2000, and actually to a certain extent it's still true now, um, which is known as a browse wrap contract. And under these types of contracts or terms of use, it says, no, if you read, I don't know if you bother to read the terms of use in websites, it says that when you visit our website, the mere fact that you access the pages, you are now bound by our terms and conditions. I remember back in the early aughts, there were newspaper websites in the Philippines, news websites, which had this provision. And therefore, if you go to their site, immediately you're bound by their terms and conditions. And if you don't follow their linking policy, it used to be that you could not link to the story directly. You can only link to the home page. So if anybody violates that, they said you violated our terms of use on the basis of, because you browsed through our website, you are now subject to those terms and conditions. Okay, so that's one type of contract. And the question now is that a valid type of contract? And the answer to that question was answered way back in 2000 also, in the US case of Spec versus Netscape. And in that case, the court recognized that when you have a browse trap contract, or when you merely surf to a website, you're not even aware that you're entering into a contract. Because you're not aware you're entering into a contract, how could you be bound by terms and conditions set, right, unilaterally by the owner of that site? And therefore, these types of contracts are considered not valid. So if you want to have a valid contract on your website or on your app, what you need to do is what the court referred to as a click-through contract. And in a click-through contract, this is one where there's a window that comes up, the terms and conditions are presented to you, and at the bottom, you click a button that says, I accept. Right? I'm sure a lot of you have seen that type of contract, and I'm sure a lot of you, if not maybe 99, or maybe all of you, none of you have read those terms and conditions. Even I actually, if I'm just going in, I don't bother to read it. I just click on the buttons and I click, and that's called a click-through contract. And the validity of that has been upheld. In fact, there were a number of cases in the US involving arbitration clauses that were embedded in these click-through contracts. And the courts required the parties to go through arbitration because the click-through contract is a valid mode of contracting. Okay. Uh, what about contracts that are unsigned, right? Should we be worried about them? Well, the answer for that is no, because unless the law specifically requires that a signature is necessary for that document to be valid or that contract to be valid, then as I mentioned earlier, so long as the elements of the contract or the offer and acceptance are in an electronic document, they would be considered valid. Okay, and in the case of unauthorized documents, contracts, we discussed that already. Okay, so I'll just move quickly now, just very briefly to the rules on electronic evidence. Then we can go to our Q&A, and I think there are a number of questions that are already up there. I hope you guys have prepared, you have a lot of questions for us. So on the rules on electronic evidence, so this was about a year after the E-commerce Act, maybe 6 months after the Supreme Court constituted a committee and our chair was retired Court of Appeals Justice Elvinas, and he led our team. We were Francis Lim of Accra was there, myself, Lito Averia, Abet de la Cruz. So we put this thing together, and we came out with the rules on electronic evidence, which the Supreme Court enacted. And initially, actually, it only covered civil cases and not administrative cases, but not criminal cases. Okay, so there's some few misconceptions about electronic evidence. So first, that electronic evidence, even back in 2000, right, was new to the Philippine legal system. I will argue that that even long before the E-commerce Act was enacted, evidence of electronic, optical, etc. Those things were already considered admissible. What created, I think, the confusion was there was a case involving IBM where back in the 90s, IBM had an email system, an internal email system. And then there was an employee who was not performing well. So the employee received notices, right, saying, I think it was about concerning attendance, right? So this person was coming in late, and a lot of email evidence was sent there. And in fact, the notice, the two notice rule, to satisfy the two notice rule to terminate, both notices and even the notice of termination was sent by email. So this was, the person filed an illegal termination case against IBM. And, in labor cases, it's before the labor arbiter, and there is what you call a position paper before the arbiter. The counsel for IBM attached all of the emails as an attachment to the position paper. Case went all the way up to the Supreme Court, and the Supreme Court said that the emails were inadmissible as evidence. Now, and this is where the confusion started, because it created this this perception that that electronic mail or email is not admissible in evidence. But if you read the case closely, what the court was saying was that it's not that the email was not admissible; it's the fact that it was not authenticated. Because under the rules on evidence, if you're going to submit a document, you must authenticate it. So what was missing was those emails, because they were printouts, should have borne a stamp and a signature of a company representative saying that this is a certified true copy of the email that is within their system. Because if back then they could not, I'm sure there was no remote access that they could have done within the labor arbiter's office. Okay, so electronic evidence, the rules on electronic evidence, and the E-commerce Act did not make evidence admissible. Even documents prior to the time that were in electronic form were already admissible. In fact, I look at the rules on electronic evidence and even as an E-commerce Act as merely confirming, right, explicitly confirming the fact that electronic documents are recognized, are valid, electronic signatures are valid, and confirming that electronic evidence is admissible. Okay, and as I mentioned earlier, the rules on electronic evidence does not allow notarization, electronic notarization, nor electronic filings of pleadings, which is something that the Supreme Court now is also looking into. Neither is the rules on electronic evidence the final word on electronic evidence. And in fact, the new amendments, the rules on evidence, adopted some of the things that we put into the rules on electronic evidence, particularly the duplicate, the counterparts provision for the best evidence rule. Okay. Also, there's some perception, which is not true, that the rules on electronic evidence does not apply to criminal cases. So originally, when the rules were enacted, the Supreme Court did exclude you could not use electronic evidence in criminal cases, but that only lasted for a couple of months, and the Supreme Court quickly amended the rules on electronic evidence to include criminal cases. In fact, this has also been confirmed by the Supreme Court. Okay, so how do you present an electronic document? Well, the shortcut is a printout. You take an electronic document, you print it out, it is considered the best evidence, or that is the original that you will present in court. But the printout, but you also have to show that it reflects the data accurately. So a simple way to do that is you have the printout and then you compare it to the electronic copy. Now, what some lawyers do is they even attach the soft copy, they burn it on a CD, and they present that soft copy to the court as well. Okay. Another type of original is what's known as a duplicate original, or a counterpart which accurately reproduces the original. And actually, the intention here is to include things like photocopies. So a photocopy now is really supposed to be the same as an original. Unfortunately, there is a Supreme Court case involving the National Power Corporation, (NPC). I believe it's NPC versus Codilla, where the Supreme Court held that photocopies are not considered duplicate originals. But interestingly enough, this duplicate original rule is now part of the rules on evidence. And one of the big questions, I think, moving forward is whether or not photocopies will be considered as being equivalent of the original. It used to be, the general rule under the rules on evidence that if you're going to present a document an evidence, you have to show the original, meaning the one with the actual signature of the person, the one with the wet signature, right? And you cannot present a photocopy. Under the duplicate original rule, which is now in the rules on evidence, that would now be possible. So actually, a few weeks from now, we're going to have another episode on this where we will discuss the impact of these new rules on evidence on the rules on electronic evidence. Because I think there's some confusion on how those two interface. Okay. And of course, as I mentioned earlier, a document under the rules on evidence must not only be the original, but it must also be authenticated. And how do you authenticate? Okay, so first you authenticate using the rules before, which is by evidence of anyone who saw or the execution of the agreement. But additionally, if it is digitally signed, right, the fact that you can prove the digital signature, the document is also authenticated. So this is something that we put into the rules because it was our position that digital signature was a valid signature under the E-commerce Act. And if it's a valid signature, in the course of proving the validity of the signature, you're also authenticating the document. Because one of the features of a digital signature is it confirms, right, mathematically through encryption, that the document has not been altered from the time it was signed to the time that you have confirmed its contents. Okay. And finally, actually, the catch-all here is by evidence showing the integrity and reliability to the satisfaction of the judge. It's a very broad standard to authenticate an electronic document. When it comes to electronic signatures, as I mentioned, the problem is really Section 8, which we discussed earlier, a very long and complicated provision of law. And in fact, I like to call it the Frankenstein provision because, in fact, many parts of the Section 8 of our E-commerce Act was taken from the Singapore Electronic Transactions Act. And that law was a digital signature law. That's why when you look at Section 8, it seems to hew closely to digital signatures. Unfortunately, our law was supposed to be technology neutral. And so it creates this bizarre situation where we copied from something that is supposed to be for digital signatures, but we want to make it apply to things that are beyond digital signatures. As I mentioned earlier, at the time that the rules on electronic evidence was written, digital signatures were widely used, and our belief, at least our opinion, was that they are considered valid under Philippine law. And how do you prove a digital signature? So long as you have a method to show that they exist on a document and a method to verify. And once you show the court the electronic documents that satisfy this, then the digital signature is authenticated. And as I mentioned earlier, the moment you authenticate a digital signature on a document, the document itself is also authenticated. So it's a 2-for-1 deal when it comes to digital signatures. Okay, and of course, the catch-all again is that the authentication of an electronic signature other than a digital signature which satisfies Section 8 by means satisfactory to the judge would be permitted. Okay, what about other concerns, other things that are covered by the rules on electronic evidence? First is the method of proof. Now, we believe then that one of the problems of presenting an expert witness when it comes to electronic evidence is that it might be difficult to have a direct examination. Therefore, we actually put in a rule that allowed the direct examination of that witness to be done in electronic form, in affidavit form. So this is a precursor to the judicial affidavit rule. Second, we also included a provision that allowed remote examination of witnesses via teleconferencing. The only rule is that you have to apply for it and that the judge can impose conditions. So actually, that is now the basis, right, for the courts. Also, one of the basis for the courts to adopt teleconferencing rules in terms of moving forward with presentation of evidence. It's allowed under the rules on electronic evidence. Another rule that found its way now in the main rules on evidence is the business records exception. And this was actually suggested by attorney Rolly Vinluan, who because they have cases, they have cases involving corporate clients where their evidence consists of records of these corporations. And under the business records exception, you can only present electronic records or records of business entities. You have to present the person who actually was the custodian at the time that that record was made. And as you know, with people changing jobs, it becomes very, very difficult sometimes to locate this person. And the Supreme Court rulings went so far as to require either that person was dead or that person is so far away that he cannot be brought back. Otherwise, that person must be presented. So now, any person or any custodian of business records can authenticate. So initially, when the rules on electronic evidence was enacted, this was an advantage to having electronic records because with electronic records, any custodian can testify. With paper records, only you have to follow the rules, right, or the jurisprudence by the court. But now with the rules on evidence having been amended, the rule now is consistent between both types of documents. We also had to include a provision on audio, photo, and video evidence. Only because in some instances, these types of evidence are really documentary evidence. They are documents. And the requirement here is that if you are presenting the truth of what you are seeing in the document, in the video or photo, then you must authenticate it. But if you're not using it to prove the truth of what is contained in the picture, then you do not need to authenticate it. So a favorite example of mine is, let's say you have a case where the plaintiff, right? The plaintiff is suing because he was run over by the defendant using his yellow Mercedes-Benz. And so you are now understand and you show him a picture. Mr. Witness, I'm showing to you a picture of a Mercedes-Benz. Now, if the picture of the Mercedes-Benz is the picture of the car that was in the accident, right? And you're having the person, the witness, identify it. Now you're treating it as documentary evidence because you're proving the truth of the information contained in the picture. So in that case, you have to authenticate that document. Now, but what if you're just showing let's say a promotional photo sold by Mercedes-Benz and say, Mr. Witness, the car that hit you, did it look like this? Right? So in that case, you're not proving the truth of the content. You're using it merely what's known as object evidence. And therefore, you don't need to authenticate that picture because you're only using it in order to inform the court that this is what, according to this is what the car looked like. Not that was the car involved in the accident. Okay? And then, of course, as part of that, we also included a rule on ephemeral electronic communications. And these are communications that like telephone conversations or SMS messages or even email messages that are routinely deleted, they may be proven now by secondary evidence or testimonial evidence. And that's it. That's basically my short presentation on electronic business, electronic contracting. And I think from here, we can probably go to a Q&A. So I'm going to bring Cassie in, whose video is not on.
Yes.
Cassie?
Yes, I can't. It's unable to start video because I need to have host, but it doesn't matter. It's okay. So the question, okay, there's a question here. Is an electronic contract valid if a person entered into it, but he or she is not designated approver, but receive a verbal go signal from the designated approval?
Hold on. Okay, so
Yeah.
I think now you're allowed to,
Okay.
is
All
that
right,
right?
hold on. Yes, perfect.
There
There
you
you go.
go.
There
Okay.
you go. Okay. All right. So yeah. So there's a question here. So what if there's another person who said, "Okay, go ahead and sign the contract in my behalf"? Is that possible?
So this is sort of like an agent. So,
Mm, yeah.
okay. Yes. So of course, agency, that type of is allowed. Uh, you can designate an agent, and a person is that agent can sign an agreement for you. In fact, in many cases, like say corporations, they don't have a choice because corporations can't act. They're not people. And therefore they need to act through their representatives. So they would do it through
Okay.
a representative.
But it is important that it says like care of, right, of this person who said who gave the verbal agree or verbal directive to sign it. Kailangan pa rin ba yun yung care of?
The authority,
Yeah, the authority.
yes. As a general rule, a verbal authority would be satisfactory. But in some cases, like we mentioned earlier, so for
Mm.
example, if you're going to have authority to say sell land, then you have to satisfy the provisions of the civil code on that. And
Okay.
that is required actually to be in a public document. So that's tricky to do electronically.
All right. So the next one is an electronic contract valid if a person entered. No, we're done with that. Okay. Next, what will happen if the contract that is already notarized, but the other person didn't sign yet? The other party didn't sign yet, but it has
Okay,
been
so that's
already
interesting.
notarized.
Uh, okay, so this is tricky. Um, because when you look at notarization, if you bother to read the acknowledgement of a notary, what it says is that that person actually appeared before the notary, right, and signed it in front of the notary and attested to the notary that he did so voluntarily. So how is it possible that the document is notarized but the document is not signed? So this is one of these things where it has become standard in practice, but actually it's not valid. The proper way to notarize a document is you have to appear before the notary. Now, a related question is, let's say you have a document, like a buyer seller, and you have the exact same document, but the seller is in Cebu and the buyer is in Manila. Now, can theoretically, it's unless the one in Manila goes to Cebu, right? The document can't be notarized in Cebu only, right? Because you have to appear. The signer has to appear before the notary public. So in that situation, what I recommend is the seller will notarize in Cebu, only one signature. And so that version will only show one signature. And then the second party in Manila will attest in Manila, sign before a notary public in Manila. And what you do is you attach both documents to each other, and both documents constitute the same contract. What you can do also in that situation is you add a provision, what they call a counterparts provision, which says that the agreement can be signed in counterparts, in each part or taken together constitutes one document. So that's the
Huh.
one way to do that. Yes. So
Okay. Okay.
it's not illegal to notarize just one signature. Let's say you have a contract with 10 people who are supposed to sign it, but only one person will sign, and only his signature will be attested to by the notary. That's perfectly allowed, because in fact that's the truth, right? Yes.
Okay. So does BIR accept e-docs now and e-cigs as official actually this is a good question. So does BIR accept e-docs and e-signs now as official and submitted documents such as records, invoices? Yeah. So what about invoices and electronic receipts? Because I also like experiences, like big corporations is even if they are modernized, right? But they still don't want to accept this. So you'll still have to send it via courier, whatever, the
Right,
receipt.
right.
Right.
So the Section 27 of the E-commerce Act required all government agencies to transact electronically. So the BIR actually has been transacting electronically with taxpayers for many years now. But of course, you have to follow their rules. So they have standards on how you will issue electronic invoices and how you will issue electronic receipts, and so you have to follow those rules of the BIR. But the
I
answer
get,
would be
yeah.
yes.
Yeah, so I guess you should still put like the BIR official receipt number to that electronic receipt, or
But
scan it and then
yeah,
send out the yeah.
yes. So I'm not a tax lawyer, but
I'm
my
sorry, but
recollection,
okay.
yeah. My recollection is that the BIR has authorized certain providers, or
Okay.
you can have your system, I believe, accredited by the BIR, and once it's accredited, then they will recognize documents or electronic invoices and ORs coming out of that system. But you would need to get BIR approval for that, because obviously that allows them to keep track.
Okay.
Yes.
So I just joined since my meeting ended late. Okay, no, later. If the parties to a contract are both working from home, what is a legally accepted procedure for the execution of the contract? Okay. I think we just
So I
answered
guess I
that.
think that the question is that
Yeah.
what if you have what's the word? Yeah. So you have two people working in from home, and can you enter into a valid contract? As I mentioned earlier,
Mm.
one way is you can just send emails to each other. You could, Viber messages would be sufficient. Of course, I mean, I guess it would depend on, say, the value of the contract and how much security you really want and how complicated the agreement is. So obviously, if you're going to sign, a 10-year services agreement, say, to provide electrical power to, say, a certain to the National Power Corporation, you don't want that in a set of emails back and forth. It's a complicated type of contract. And therefore, you would have to constitute sort of different ways in proving the consent of the party to that particular type of document. And this is where solutions like Adobe eSign, I think it's called, and DocuSign
Mm.
come in,
Mm.
because they do they have features that allow parties to sort of lock in what the terms are, and then the signature, quote unquote, is really a layer that says, where, because the person had access to the document under certain through the technology, it will show that you gave consent to that version of the contract.
Okay. I hope that
Yeah.
answers your question. Well, it was anonymous. Okay, next here. Can an entry of an OTP via SMS considered as an agreement to a contract?
So the OTP isn't supposed to indicate your consent. So the OTP, the one-time password, we receive that by SMS. Sometimes, so this is two-factor authentication. Sometimes you have to use Google Authenticator or Authy. Um, and what the purpose of that, of course, it has something to do with, the signature. But really, the purpose of that is to indicate the identity of the person giving the consent, right?
Mm.
In other words, I'm on the web. I'm supposed to authenticate something. I've already entered the system using my password. So in other words, whoever it was, but if assuming it's a hacker, then
Oh, be able to go in.
that person might have had my password, but it still
Mm.
could be a hacker. So right, another layer to say that it's actually me who's approving it is that we'll send you an SMS. And so now, right, when the bank is questioned, you question the bank, why did you approve that? Sabihin ng bank sa'yo, well, number one, your password, you entered the password. And second, obviously, since we sent the one-time password to your mobile device, that means that the mobile device must have been in your possession. And because it was in your possession, that is probably you. And this actually goes back to that I don't know if you saw this thing that was going around social media about this lady who gave up her SIM to somebody pretending to coming from a telco provider. Because if you give up your SIM, then you destroy this OTP, two-factor authentication process. Because then now the hacker, if he knows your password, first he can change your password, right? And then they'll send the OTP.
To
They have
his, yeah.
the SMS coming in, so they'll be able to enter the code. So that's the danger, really, that you should never surrender your SIM to any third party, because once they have your SMS access to your SMS, then they can change your password and basically lock you out of your accounts.
Okay, great.
Yes.
So I know DocuSign will be discussed next week. We'll appreciate a yes or no answer. Is it valid or legally recognized? Signing a con. Sige.
No, I think we'll discuss that next week. It's not that it's not a trivial question. It's not a trivial question whether you don't say just yes or no. There are, and it's really not just a question of valid invalid. I mean, there are related issues to that. In fact, there's a question here by RM. You see this, right? So RM was one of our attorneys who's moved on to bigger and better things.
Yeah,
And he's asking about, he's
I was
asking,
ignoring
what
him
about,
actually.
ano?
Joke. I was just kidding him. Like, Ariel, I'm not gonna answer. I'm not gonna ask your question. You left us, but yeah.
So the question here is, what measures can you assure that the electronic signature was assigned by the appropriate individual? So RM
Uh-huh.
is talking about identity again. How do you know that it's that individual? And DocuSign does this by sending the document to the party who will sign the document. So and then you can even put in two-factor authentication. So in other words, this person had to have had access to that email account, right? And then on
Mm.
top of that, if you factor it, if you have two-factor authentication, you have access both to the email as well as the mobile device, and that gives you a high level of um, confidence, right? That is the individual who signed that document. I mean, another way, if you want to really authenticate email, is to use what do you call that? To use IP address. You look at the header of an email and you find out, what is the IP address of the person who sent this email, and if that originating IP address is a valid one for that particular domain, then that gives you a sense that this is probably an authentic email.
Okay, so an employer signing from a company who needs to sign a waiver, a quick claim, can it be done electronically?
Okay, so a release waiver quick claim is a good question. No?
Mm-hmm.
So the first question you have to ask yourself, is a release waiver quit claim, is it necessary for that to be signed in order for it to be valid? And I think the answer to that question is probably no. I'm trying to think now if I could be wrong. Baka magwala yung mga labor lawyers in that. So if a release waiver
No.
quit claim doesn't need to be signed, then it can be done electronically. But ito yung problem mo. There have been many cases decided by the Supreme Court, where in an instance where the individual received money and signed the release waiver quickly, where that person can revoke, repudiate the release waiver quick claim. So that's a very sensitive process legally, and therefore in many instances, I don't think how do you call this? Lawyers are comfortable having their clients having their clients do this electronically. And they would rather have the person come in face to face, get the notary in there, and the notary now will basically confirm that the signature was done voluntarily. So while legally you can say there's no problem, but as the question posed by RM earlier, right? If the other side is going to question and there's a risk of the document being set aside, then you're better off getting a wet signature.
Okay, so is blockchain digital signature valid?
That is a very interesting question. So if you understand digital signature technology and you understand blockchain, um, you know how if I send, say, Bitcoin to you, Cassie, you need to give me your Bitcoin address, right?
Mm-hmm. Mm-hmm.
Uh, So your Bitcoin address is actually sorry. So in digital signature technology, there's a key pair. There is a private key and there's a public key. The private key is what you use to sign documents, and the public key is known by everyone. The private key is only known to the signer, to the one who's signing. Okay, a Bitcoin address is a public key. So the Bitcoin protocol, Bitcoin technology actually uses key pair technology. But see, that's the interesting thing. So if Bitcoin uses elements of digital signature technology, then how can you be anonymous in Bitcoin? Well, because that's one of the things that's why I said digital signature with PKI, or what they call public key infrastructure. And it is that infrastructure, right, that determines the identity of the person holding the private key. In the case of Bitcoin, you don't need to prove your identity, right? You just need to have your access to the private key, is enough, right, to authenticate the transaction on the blockchain. And in fact, um, they say they have these things called these parang dongle devices they call cold wallets. Cold wallets actually contain nothing but private keys, and private keys, private keys, which are then used to transact on the blockchain. So those people who lost bitcoins before, what they lost actually are the private keys.
Yes, yes.
Yes.
Okay. So after the scan, signed document, soft copy received through email, is this enough and approve it, or need to produce the original copy? Yeah.
After the scan, signed
Scan,
document,
signed,
soft copy received through email, is it enough evidence to prove it, or do we need to produce the original copy? So this is an evidentiary question. Now, what's interesting here? Wow, there's the next question is from a law professor. I have to be careful, and bar examiner. Siguro, next time, don't dismiss the question. I need to see the answer. Sorry, I need to look at that question again. So that question was more of a question on evidence, no?
Yes.
A question if it's
So
been
after
signed.
the scans, after the scan, signed document, there's a soft copy that they received, right? Now
Right.
through email, and then now they're asking, do they also have to keep the original copy as an evidence too?
Original copies evidence. Right. So
Yeah.
so this is going to be one of the things we'll talk about when we talk about the rules on the new rules on evidence, because they've just been amended, and how they interface on the rules on electronic evidence. Offhand, I would say that a photocopy now of a document is the same as an original. It's now considered the best evidence and therefore admissible. So arguably, a copy done electronically would also be considered a counterpart, a duplicate original, right? And only under certain circumstances, basically fairness in issues where it would be fair, right, to require the original to be produced. The duplicate original or that copy would be sufficient. Also in cases where the original is lost. But now, ang maganda, you don't have to prove that the original is lost because a counterpart original is the same as an original.
Okay. Attorney JJ, it's 5 o'clock, but we still have about 10 more questions, and I feel like there are few more that's coming in. Shall we proceed?
Yes.
Okay. All right. Okay. To those of you who are still in here, please feel free to ask your questions, and we'll try our best to answer them. Okay. So if I sign a letter, take a photo of it, and scan an email to someone.
You missed the other one. Let's ask that.
No, Professor Coronel.
Yeah,
Okay.
so professor and bar examiner and former law partner of Professor and PCTG Chair Heidi Yora, Professor Sandy Coronel.
Of course. So she's asking, the SC just conducted oath taking of bar passers. Interesting. Via Zoom. So is this valid? So isn't that precedent on validity of oaths made via Zoom? Actually, is Zoom even valid?
Maganda nga yung that's an excellent question. So
right.
I think what Professor Sandy is saying is that the Supreme Court created their own precedent. They accepted that as valid. In fact, if you look at if you're my Facebook friend, I was watching the recorded version, and there's a part there where during the oath taking, what they did was they asked all of the, I don't know, let's say all the passers to turn on their mics on Zoom, and then they all swore at the same time. And then in the middle of it, there's this girl, while the oath is ongoing, there's this one bar taker or whatever. You can see her, she's fixing her hair. She doesn't even have her hand up. The question now is she a lawyer or not? So that's a very good question, whether that's basis. I would think that if you're taking the oath before a judge, yes, I think teleconferencing would be perfectly valid. If the judge is satisfied that indeed that is the person, satisfied that the identity has been established, and that the oath is validly taken. Now we have to consider also that in the case of the Supreme Court or admission into the bar, the oath is repeated and actually signed. There's a wet signature will be required, and then lawyers will have to sign on the role of attorneys anyway. So the ceremony is more of a ceremony for family. So you go down to, it used to be PICC, I don't know if they change venues, and then you you take your oath so that everybody can see it. But the official one is when you go to the Supreme Court, also with family members, another photo op, and then
To sign it.
you actually sign in
Yeah.
the role of attorneys, and it becomes
Yeah.
official.
And actually, this is interesting. I saw also in Japan, they created robots, and then there's an iPad, and then there's a face of the person. Like, so there's a robot, it's walking, and then there's a face, and then they were taking their oath. It's like, what? That is so interesting. Okay. Well, Japan. So, okay. Can employment related documents, sorry. Let's go to the other one. If I sign a letter, take a photo of it, and scan and email to someone who needs to rely on the validity of my signature, bank account transaction, instruction, would that be valid or binding proof that okay, so banking, that the letter was indeed signed, or will I need to sign the hard copy? Okay, I guess this is more for like financial
Yeah, I
evidence.
mean, that this is tricky, So I know that there's this thing that banks are required to do called KYC, know your customer. This is an anti-money laundering measure, right?
Mm.
And certainly one of the requirements of the of KYC processes. There are different kinds, but one of them is you send a signed copy of your signature. In fact, sometimes they have you take a picture of you with your signature. You hold your signature up like this, right? It's got your
And then take a
signature
picture.
there, and then you take a picture, right? Or
Yeah.
then you take a
Mm.
picture with your ID to indicate that it's you and that is what your signature looks like. Um, as I said, it's very few instances in the law where a signature is absolutely necessary in order to make it valid. When a signature is required in a banking transaction, it's more of an indication of giving your an instruction, right? The validity of your instruction to the bank to take money from your account and transfer it to a particular place. And in many of those, if you do mobile banking at all, there's no
Mm.
signature involved. In fact,
It's an
I think
ID.
the Union Bank app allows you to move, assuming you have that much money. I think up to like 25 million pesos per day
Mm.
through the app, and no
Mm-hmm.
signature. So signature is absolutely not necessary. If they require it, it's not a question of sort of legal requirement. It's more of a risk assessment from their standpoint, from the bank standpoint. And that this doesn't relate to whether it's valid or invalid. It's more of, are they compliant with their anti-money laundering risks? So it's more of a risk assessment on the part of banks. That's why they require or do not require these types of authentication.
Okay. All right. So can employment related documents generated by HR system and platform be considered as valid? Okay. Approval of document and acknowledgement of the documents captured in the system based on approval. HR system platforms are workday being used. Okay. I don't know if you kind
Yes,
of
I think
understand it.
the
Yeah.
question is that, so you have an HR system that has, for example, a record of your leaves, indication of say application for leaves, disbursement requests,
Mm-mm-mm.
whatever, right? Anything that you
Yeah.
put on there, maybe submission of sick leave documents, um, you know,
Benefits. Yeah. Yeah.
benefits,
That's, yeah.
social security, SSS benefits,
Mm.
saka maternity benefits, you upload it, and then it's processed that way. And the question now is that, are they considered valid? As I mentioned earlier, those electronic documents, right, will be considered as equivalent
Mm.
to written documents. So they would be sufficient to prove that the document exists. As to the specifics, you would have to go on a case-to-case basis because it really depends on how the system works. I mean, you can have a situation where there's the system. It says this. It says that it says Cassie, for example, made this request, and it turns out that, for example, that you don't need a password to do that, right? Then you can say, Cassie can say, well, I didn't do that. That was somebody else, right? So in that situation, you can say, well, that's an electronic document. But whether or not we will believe that it's an action of Cassie is another thing, which reminds me of an old story back when there was, I don't know if you remember this, Cassie.
Mm.
There was this online for a while, Sage. The name of the company was Sage. They got a license from Pagcor to do online casino in the Philippines,
Mm.
and
Mm.
they were running blackjack. And then there was this guy says that he lost, I think, about 10 or 20,000 pesos. He lost money because what happened was he was playing blackjack on his computer, and then he went to the restroom. And while he was in the restroom, his 3 or 4 year old played, just punched on the
Oh,
keyboard,
okay. Yeah. Mm.
and he said, can I have my money back? And of course, ang kalaban niya is the house. So they said, sounds like he just wanted his money back. But they checked the records and they checked this playing record. His playing style is very consistent. So if it's blackjack, he hits if it's a certain number. If it's higher than that, he stays. I don't know the details, right? So, and that for that period where he said that he lost that money, it's very clear that the playing was erratic, right? So they said, oh, it's probably true what
History.
he said. And on that basis, right, these are all electronic documents. It's one thing to say that it's a valid electronic document, meaning we can it can be the basis of a legal obligation. But it's another thing whether you believe the content of that document.
Okay,
Okay.
interesting.
All right.
What are JJ? I have a personal question also. In terms of like these documents, like Hello Sign, DocuSign, all these signs, right? They already embedded sample signatures that you can actually use as a signature. Is that even really valid? Because it's
Yeah, no,
not, yeah, right?
you type your name and it looks like it's a signed thing.
Yes, and it's, yeah, they have a suggested font that being used in there. So
Correct.
how, I mean, I love using all these apps because it makes our life easy, Rick, totally. But is that even valid? Or yeah.
So like what I said earlier, an electronic signature is a mark, a distinctive mark that you adopt. So you can adopt whatever mark you want, di ba? Some people the mark they adopt is an X. Some people the mark they adopt is their thumbprint.
Yeah,
Okay.
but they don't have
But you
a,
adopt
but
it.
yeah, but there isn't a rule like, diba, sabi nga nila, I mean, at least
Yeah.
before that when you sign something, it has to be the same signature of another ID. So, syempre magkaiba siya
That's
ng curve, whatever, right?
yeah, I know, but
Mm.
people's signatures change over time,
Mm.
right? And if an X can be adopted by a person, or like Prince adopted the TAF cap, the artist
Mm.
formerly known as Prince adopted a certain logo as his
Mm.
signature. And I think in China, what they have is a chop. So you have this device. It's not even made by you; it's made by somebody else. The point is that you adopt that as your own, and the fact that you adopt it, so I guess what I'm saying is that the fact that you adopt it as your mark to indicate your consent to that document, right? That would be an electronic signature. Now, whether it's valid under Philippine law has to satisfy section 8 of the statute, and we'll go into that in more detail next week.
Okay, so
Right.
I won't dig into that anymore. Okay,
Yeah.
so is blockchain proof of identity a transaction under E-commerce Act?
No, not by
All right.
itself. As I said, you can be anonymous on the blockchain. Now,
Yeah.
you could, if so right now um, the BSP authorized virtual currency exchanges to operate. So you can now buy, say, Bitcoin. You can buy Bitcoin, say, through coins. All right. Now, Coins now has to do KYC on you. They have to make sure that they have to bind your identity to the Coins address. Now, one way to do that also is to prove that that Bitcoin address is your Bitcoin address. So that's one way to sort of link an identity to a specific Bitcoin address.
Okay. So if my client is negotiating a contract which is in Word format, but due to lockdown, parties cannot meet, can they sign the printed contract and counterparts? Okay. Then scan an email to the other party under the law. Could that be considered valid? Yeah, of course. But okay, Attorney JJ.
No, I was saying is that okay. So the first question that you have to, when you analyze the sort of things, the first question you have to ask is, does that contract need to be signed to be valid? Okay, so as a general rule, the answer to that question is no. There are very few contracts that require it to be signed. Because once you require once you require a signature, once the law requires signature to be valid, then you need to apply Section 8. You have to go through those. You have to go through those hoops. But as a general rule, it's not required. So what are you left with? These signed documents, right? These signed documents are now evidence of offer, evidence of acceptance. These are now electronic documents of what you agreed on. So the taken together, yeah, you'll be able to prove that this is the contract that they entered into. And then but you will have to link it to the emails. So you have to present everything, right? Because you have to say it came from that email, and then I received it. And then you can also present evidence to show that you've received emails from that person using that email address that are definitely his. and you can also bind that email address, for example, to a certain IP address, and there's consistency in the use of that IP address sending emails. So you have a very high level of authentication there.
I think this question may have been it may have came from someone from the financial sector, like insurances, right? There's a rule in insurance wherein you have to sign a document right in front of me in order for it to be valid. But now that there are new rules in terms of insurances, I'm not really that particular if it's
No, but for
really valid now.
identification, the BSP nga allows remote KYC. So
Okay.
this is why banks like CIMB and ING, you can't go to, there's no ING branch you can go to, but you can bank with them. In fact,
Online. Yeah.
I saw a promo, something like you can deposit up to 10 million, they'll give you 4% interest. I mean, beat that. And that's like, everything's electronic, right? And
Yeah.
everything's, there's no face-to-face. You don't need to go anywhere. There's no branch to go to.
Yeah, there's no branch, right? So, okay.
Yes.
So if a board meeting is held in via telecon, can the minutes and board resolution be signed electronically by the directors?
Theoretically, yes.
Yes.
There's a way to do it now. And really that's a risk question now for the corporate secretary, right? So you may adopt. All you want to know really is that you want to make sure that that particular director approved it. Now, if it's recorded, if there's voice recording, and this is required actually under the rules, what you do is you have the board director identify himself in the recording. So like JJ Vicini, director, I vote yes. So then now that is your evidence, right? That he voted that way. Now on top of that, if you want him to digitally sign or physically sign and send you a scan copy of the resolution, that's more protection for you.
Right. So that is why like minutes, right? The board minutes, they usually like read it first before they agree that it was actually said. So yeah. Okay, next.
Questions.
Oo nga, dumadami. Oh my goodness, this is so great. We welcome almost 300 people in the room today. So that is great. So we're down to 130, but it's fine. Okay, so it was mentioned earlier that email contracts are considered valid. Is it true for trust agreements and investment management agreements and other related documents such as, you mentioned this a while ago, account opening forms, risk disclosure, so on and so forth. Yeah.
Yeah, so I would, that's tricky. That's parang, this is not purely a legal question. It's also a risk question. So it's something that you need to sort of negotiate between legal and your risk guys, whether that would be, because but legal validity is one thing, right? And then whether you're willing to take the risk, and if you want to take that analysis, if 360 mo siya, you also have to consider what's the evidence you'll present in court. Because if it turns out later somebody's going to question it, what will the judge see, and will that evidence be available to you when the time comes? Yes.
Okay. More questions coming in. Hey, you guys. Okay, so is it correct to state that as a general rule, any agreement required to be in writing may be executed digitally, except those which are required to be notarized?
Yes. If it has to be in writing, it can be done electronically. The requirement in the E-commerce Act is that you need to present evidence of its integrity and reliability, and that actually is a sort of that's a very loose bar, or very low bar, to meet. So yes, as a general rule, you can prove that it's in writing. But as I said, contracts that are an oral contract is valid. That's not in writing. So I look at some electronic, like an email, for example, let's say you don't satisfy the integrity and authenticity for an email, you don't prove, then it's equivalent to like a verbal evidence, right? And therefore, if an oral contract is valid, why can't this be valid?
Okay. So hello, my question on Zoom oaths leads to possibility of valid notarization via Zoom.
Oh, that's probably that's true. I think the only problem, madaming complications in notarizing via Zoom. And I think one of the, I'm certainly in favor of that. Ang require ko that if I'm a notary let's say Cassie is my notary. I say, Cassie, I swear to you that this agreement here is, I gave my consent. In fact, I'm going to show you. So it require ko that I see the person sign, right? And then they will send me an electronic copy of what they signed, and then send it to me physically. And then when I'm going to fix the dry seal, we initiate another Zoom call. I will look at the signature and I will ask you again. Itong
Well
signature na to,
documented. Yeah.
yeah, so you confirm all elements, right? And that will take a long time, but then you'll be able to do that, and then you can reflect all of these measures. So hahaba lang yung documentation kasi sabi mo you took these measures to ensure, right? The ano. And in fact, when you do that, that's even better than because you can go some notaries, even if the person is not present, they will notarize, right? So this is actually better.
Okay, so Gwen is reinforcing a question like, what are your thoughts on banks that adopting digitalization of bank documents?
I'm all in favor. I mean, money is actually electronic, right?
Mm.
If you look at the number or the amount of, I think it's only about 4% of the entire money base is actually in paper form. So money starts electronically, and it's just electronic entries all over the world, right? In computers, entries in banks. So
Transacted.
why can't you? There's no reason for it
Wire
not to
transferring.
move in that direction. And
Absolutely.
the only reason is that maybe parang it's more of like it's difficult kasi to prove it in court. So the apprehension doesn't arise because of what the law allows, but the limitations of what the courts are able to accept comfortably.
Okay. So if a digital image of a signature is affixed on a contract by a secretary after getting an email approval of it, is this considered valid?
It's a good question.
Yeah.
Because sometimes some people do that. It's the
Yeah.
secretary of access.
Yeah. That's why you care of,
Some
right?
some people, it's the secretary who answers the email. The boss dictates it to the secretary. The secretary has access to the boss's email, and she's the one who sends it, right? Well, I know 20 years ago there were senior partners in law firms that don't know how to use their computers. Their secretaries who did that. So in that case, that's a bit tricky, but it's no different from say authorizing somebody else to sign in your behalf. So there will always be questions about, is this actually the right person? And in the end, I think if I were a judge, I'll say, if it turns out that that person did something that wasn't authorized, you know, it's the risk of the person who authorized him. Look, if I'm dealing with you, Kasi, and I don't know that it's your secretary who's sending it, then I don't even know
Might
that
not
I'm
know.
dealing with an agent,
Yeah.
right? So if something happens, you're the one taking that risk. Now, if I'm aware that it's your secretary sending me these messages, then
You can
it's
reconfirm.
turned around because under the law and agency, the one dealing with an agent bears the risk if it turns out that the agent is not authorized. That's why you have to be careful when you're dealing with an agent. So somebody selling you land, ang kausap mo agent, siya daw yung pipirma. Tapos meron siyang special power of attorney. You have to be very, very careful under those circumstances. So, for example, one of the advice I give, if you're buying land through an agent, you make the check payable to the seller, not to the agent. That way, you can at least prove that the money went to the bank account of the seller. Therefore, at least the part of uh, gaining financially is on the part of the seller.
Okay. Right. I think the professor was messaged again. Sorry, I think I pressed my mouse too early. My question on Zoom
Okay na.
oath by the SC leads to possibility of valid in notarization via Zoom. Okay. All right. Next is as part of your customer process, anti-money laundering regulations, covered institutions to obtain client specimen signature or biometric information. Can clients upload a copy of valid ID showing client signature and 3 signatures suffice? Parang ang dami mo ng proof.
Yeah.
Yeah, di ba?
So actually, ano ba yun? So locally kasi I went through this in ING. I think that I sent them a current bill. I sent them a copy of my driver's license, and I sent them a copy of my signature, and I think I took a photo with both. And then another thing they do is proof of life. So they took a video. They asked me to blink. They asked me to, and then they do facial recognition against my face, against the ID, and then they compare the submitted signature to the ones that are in the IDs. And if it's close enough, that suffices for purposes of KYC.
Okay. So some of our suppliers now, okay, last 5 questions, everyone, and then we can perhaps discuss on e-signatures on July 2. So last five. Okay. Ryan is asking, some of our suppliers now are sending us invoice soft copies due to present, of course, quarantine status. How would we know if their invoice is properly registered with BIR? Which document should we ask from the suppliers as proof? And go
That's
ahead.
a good question. I don't I'm not an expert on this. But the it's always, I think always she said so. I'm just quoting. Uh, uh, hmm. Sorry. I would look at the BIR regulations, and then
Mm,
and I would ask for some proof of that their system is authorized by the BIR to issue invoices.
okay.
Yes.
All right. Okay. So is a printout of a company's computer system which with redacted portions due to data privacy admissible in court, or is the company compelled to present a copy which has no redacted parts?
That's a very good question. Um, this is not really this is not really this is a very interesting question because there are instances where evidence must be presented, but you have to protect, say, privilege or what. The rules in the Philippines are not very clear on that point. So, for example, somebody's testifying, and then there's an objection. That's covered by privilege. That's inadmissible. In the U.S., what they would do is they would take the witness, set him aside, have a closed door hearing, and the judge will hear the testimony and make a determination whether it's admissible. Dito
Mhm.
kasi that could happen. So the judge can require, show me the whole thing, but what we will put on the record is the redacted version. And I will be satisfied that it's the same, right? And then the redacted portion is irrelevant for purposes of determining, but I could be convinced as a judge. But I want to see, but it will be a private setting where we will look at that information. Certainly, privacy in the court system is already embedded, particularly in offenses involving children, from sex related no offenses. In fact, they even go back to old decisions where they remove the name of the victim and they turn it into AAA, VVV, CCC. So you don't know the name of the victim.
Okay. Okay. So what constitutes valid e-votes in corporate meetings?
That's a good question. I guess it depends on what system you use. As I mentioned earlier, you could indicate a vote by saying your name and then
Mm,
casting the vote.
mm,
If you have a system, you have another way of indicating it. For example, if you're using Zoom and you say, "Sige," if you approve, then you raise your hand. All right.
yeah.
So when you raise your hand, then I think we
Then
have
you state your
somebody raised
name.
their hand,
Yeah.
right? And you state,
Yeah. Mm.
then
State
you
your
can
name,
prove,
the date.
okay. So when you raise your hand and we capture it on the recording that you raised your hand at that point, and that would be considered a vote. So it really depends what system. And then what you do is you confirm it later by having him sign something or maybe send an email confirmation. So you have like multiple layers if you're really really careful.
Yeah. Okay. So can we have an example for remote KYC approved by the BSP?
You know what I would do? Sorry, you want an example? Go
Mm.
through no, go through the KYC process of coins. Sign up for GCash, sign up for PayMaya. Those are all. I mean, the BSP does not say, this is what you do. You do 1, 2, 3, 4. What they have is a series of parang risk profiles, and these are the things we want you to handle. We won't tell you how to do it. So that's why the processes are different in each of these. But go through the one in GCash when they allow you to transact on higher amounts, and that's an example.
Yeah. Okay. Okay. So follow-up question on the trust and investment management agreement. If there is electronic face-to-face on file, does it make the agreement legal and binding and acceptable? Electronic face-to-face is accepted by AML.
Yeah. So yung
Okay.
AML kasi is not for purposes of making the contract valid. It's for purposes of determining the identity of the person, to make sure that to bind an identity to the money, right? And then you're not laundering money for somebody else. Because why would you do that if mahuhuli ka? That's the idea, right? Because now you're going to be responsible for that money. Now, for purposes of whether or not that would be sufficient for a contract, I go back to my answer earlier. You need to look at whether there's the law requires it to be signed, etc., and the question of risk on the part of the bank. So I mean, and then also you would need to bring your litigation lawyers into the room Because when this thing blows up, right, and you've got 1,000 of these contracts, and you have one contract where the borrower, for example, is able to repudiate the contract, you're going to see, another 999 cases behind that person. Then everything's thrown into flux, and that's something you don't want to happen. So you need to get your ducks in a row, prepare for the worst case scenario, get yourself to a point where everyone is comfortable, and that's what you implement.
Okay. Gosh, Attorney JJ, there are so many questions coming in. All right. So with
Last
manuals, yeah. So there are more, maybe last three. Okay,
right.
everybody, I can last three, and then we can perhaps read through your questions and see if we can just like answer it through maybe email or on our next session. Okay. So with manual signatures, you just present the signatory and point to the signature and ask the person whether that was his signature. How different is it to prove electronic signature? Kasi 'di ba,
It
meron
depends.
akong
I mean, sorry, electronic signature is so broad. I mean, okay, one way, okay, for example, in my case, I sign all my emails, you know this, I sign my email dash JJ, right? I don't know if you noticed that. That is actually an electronic signature. Now, whether that's a valid electronic signature is, it's not a valid electronic signature, but it is an electronic signature. If our law were written in the same way as the Untitled model law, that would be considered a signed document. That is a mark that I adopt, and then I attach it to a document that comes from me. So that would be considered a signed document. No. Now, can it be forged? Yes, obviously. So that's why while the law says it's signed, it doesn't mean it's necessarily true. And this is the same as in forged documents, right? It looks like it's signed, but actually it's not. So the document is just one layer. There are different ways of proving, right? You need to. It's like identity. It's not just me telling you that I'm JJ Dicini. Me showing you an ID is another layer. But you want to really prove that it's me, other people will confirm to you that it's me. So you want identity online, you link my transactions with
the
different
email.
people,
Yeah.
and that will create accumulation of evidence to
That it
confirm that
came
I
from
am
you.
indeed the person who I say I am. So this is the sort of thing, for example, that blockchain can do. You leave parang digital trails, connections all over the place. Then you allow people to confirm those transactions.
Right.
Uh,
So, okay.
Electronically, yes.
Okay. So how can you secure your electronic signature? What if somebody use it and you don't know about? Okay. All right. So I think you just
Yeah.
answered your
Oh,
question also.
well, no.
Yeah.
I mean, that's not. I mean, in my case, for example, so I do this, right? I use preview. You can sign, but how can you access your preview in my computer? That means you know the password to my computer to
Yes.
access it,
So
right? The
security
other one is
clearance
on
is
my
very
phone. Either you have my face, or right, or you know my passcode, and that would be my fault if somebody else knew it. So in a sense, it's not me,
okay.
but then so I can be held responsible for not securing it. So in that sense, it's still my fault. And if the other party suffered damage as a result, then I could be potentially liable.
So did you mean Attorney JJ? So what if, let's just say there's a signature that's going to be signed and then this person doesn't have an Adobe, whatever, a DocuSign, whatever. And then he or she would say, uy, pahera mo naman yan, I'll just sign it through your computer and email natin using your email. Because syempre the DocuSign has a certain email, right? That's attached to it. And in-upload niya yung document inside and then so that's not valid.
You mean they use my computer, pretended to be me?
No. So let's just say, kunyari, I have a document. Example lang. I have there was a question on kanina. I have the document. And if I have the document and then I said, Attorney JJ, can I just borrow your DocuSign? Because I don't want to go through the entire login and stuff like that. I'll just upload the document to your DocuSign. I'll sign
My
it.
account.
Yeah, using your account.
So it will
And
look
of
like it's
course,
signed by me.
yeah, it's signed by me or yeah, it's signed by me. No, it's mine. Nakigamit lang ako ng account mo, ng
Okay.
DocuSign mo, right?
Ah,
So because there's another layer wherein I know DocuSign kasi gets sent using a JJ at Decini, so it's not a Cassie Bajarillo, so it's not
right.
valid.
Well, again, it's all a question of if you have your own DocuSign account and it comes from JJDC, you're going to have to explain why this happened. Why did it happen that way? And why that's your signature? Why couldn't you log in using my computer? So it's all of that is going to come into play. Of course, obviously, if somebody wants to get out of it, right, they're going to point that out. But maybe not enough.
Yeah. Okay.
You
So
want to take this last question? This is a very interesting question.
Yeah. So those the signatories really have to sign all the pages up until now.
Okay,
Like
so
those of the side portion. Yeah.
So there's actually a case that it's so interesting. This is I was a young lawyer then, and then there was a contract, and this is a contract over a lease over a certain property, and they were fighting over this paragraph, okay, which in the version, it's such an old contract kasi back pa in the 90s, that the version of one side contained that paragraph, the version of the other side did not contain that paragraph. But if you look at it physically, the contracts are all the same. The funny thing is that paragraph was at the bottom of a page. And then, they signed on the edge, on every page. And they signed over the text, para, ano. And nagkataon lang on this page, this particular portion, the signatures were not on that part. So you could physically cut it out with the scissors, Xerox it again, right? And then it would look like it's a valid contract. And, the solution to that actually is you're supposed to have line numbering in contracts. But we don't do that here. But actually, I think we should do that now. You put line numbers on the sides of each page so that you know that there are 100 lines per page. So pag nagtanggal ka ng text, mawawala rin yung line number. So bakit absent yon, di ba? When it's supposed to contain these things. So yun yung, so the reason you sign on every page is because you can take out one page and then somebody can replace it with something else. So you sign on each page to say that, yeah, that's the page that I signed. But in the case of electronic documents, kasi, there are ways to determine that it's exactly the same document as you signed. Okay, so I guess we're a bit over time.
Yeah, we are like 4 minutes. Okay, so everybody, we wanted to thank you as well for being here with us. There are more questions coming our way with regards to e-contracts, and this is so good because we are going to have another session specifically for e-signatures and e-contracts. This is just basically just a preview because there's just so many more to discuss. Thank you so much, everyone. Yeah. So, Attorney JJ, do you have any last words that you wanted to share in terms of everything?
Well,
or you'll just see them next week.
Yeah, we hope you sign up for next week's session. We're still putting our lineup together. If you have someone you can recommend from us from Adobe, eSign, or Tiwala, please send us an email, info@dtt.ph, and then we'll reach out to them. And we're also trying to find someone at DICT to talk about the DICT system. All right?
Great. So again, thank you so much, everyone. Again, electronic signature is considered as a binding agreement, and the signature relates to associate assigned under Philippine law. It is also globally accepted since time immemorial. I guess my question, there's one more question here. I guess this is very important to ask you, Attorney JJ. Is the Philippines ready for digital transformation, and will there be standardization in terms of electronic signatures and contracts?
Yeah, I think, ready or not, we have to do it. I think we have a lot of the elements in place, and certainly we're a growing economy. There's many reasons why I think we would be successful in that regard. So yeah, I'm very hopeful.
Okay, great. So everybody, make sure you do the necessary due diligence on your providers. I guess this is the risk of it all. I mean, the summary of it all. Do the right research and choose a solution provider that uses a technology that suits your needs, and only use additional verification and validation for users. Another key takeaway here is electronic exchange is now considered as a valid contract via direct message and chat. And of course, click-through contracts is very important, and click on I accept. Well, of course, with your risk. If you want to read it, go for it. You have to, right? And in terms of the terms and conditions, and electronic contracts and signatures can be used on criminal cases. I guess that's really important. Maybe that's the reason why you guys are all in here. And don't forget, also on July 2, we are going to have another Digital Transformation Thursday. It is a free webinar. You can go ahead and invite your colleagues and your team. It doesn't mean that the invitation just went to you and you're the only one who has an access to this. No, you can definitely send it to your team members. So again, you guys, my name is Cassie. Thank you so much for joining us. We'll see you on July 2, same time, 4 p.m. And we'll see you again next week. Thank you so much, you guys. Bye.
Thank you. Bye-bye.